Patrick, can you hear me now?
I can hear you. Can you hear me? Yeah.
Okay, we're going to begin. It's 10:03 and we have all of our members present today at the meeting. So my name's Lindsay. I'm the clerk with the township. So I'll call the meeting to order at 10:03, as I said. So the first thing on the agenda is the election of chair. So I have a motion, be it resolved that the committee appoint one of the members as chair for the Property Standards Appeal Committee meeting held today, October 29th. I don't see anyone jumping up to volunteer, but I wonder if there is someone that wants to nominate someone to be the chair for this meeting. Just to keep the meeting. Just before we keep going, just make sure to mute your microphones when you're speaking. Just that main button there if you're speaking. So I have a nomination by member Karen Cheeseman. Alan, are you okay with this nomination?
Yeah, I didn't see that coming.
Do I have a seconder?
Yeah, that's fine.
Do I have a seconder? No, Karen, you made the motion, so Doug will second it. Okay. All in favor? Okay. Alan, you are the chair now. So our next motion is confirmation of the agenda. And I know our senior manager of development wanted to just give a little talk to the committee before we got started. So if we can pass it as amended to include that short discussion before we get into the hearing, that would be great.
Confirmation of agenda. Be it resolved that the committee confirm the agenda as presented.
So it'll just be as amended to include that discussion.
Anyway, declaration of peculiar interest.
Just a mover and seconder and
Okay.
pass that motion. Yeah.
Confirmation of agenda.
I'll second it.
Perfect. And just to vote on it. Okay.
Declaration of pecuniary interest. And if you don't have one now, at any time you develop one, you can do so. And no adoption of minutes because we don't have any. And number 6, hearing property standards order appeal. The first one is 71 Osprey Street, Dundalk, Ontario.
So just before we do that, I'll let Ken just give the little talk that he wanted to.
Yes, thank you, Mr. Chair, and good morning, committee. I realize that this is the first time we've constituted the committee, so I thought it would be helpful just to give you a little bit of background to your jurisdiction on the matters that are going to be before you today and the role that staff plays and how you proceed. So the matters that are before you are appeals of orders that are issued related to enforcement matters. So the thing you need to understand is that there has already been discussion with Hannah, who is our bylaw enforcement officer, and the property owners involved. So there's already been activity occurring and you have documentation of that in your package today, and Hannah will go over some of that in her presentation. What'll happen today is you'll hear from staff on each matter. So the chair will call each matter separately. Staff will provide a presentation or an overview as to the situation and where we're at. And then you'll also have an opportunity to speak to the property owners and get some feedback and information from them. Your jurisdiction really is a matter of two, I like to put it in simple terms, two simple questions. Did the municipality have a valid reason for issuing an order? And if we had a valid reason, is the time that's been provided sufficient and reasonable to achieve compliance with whatever bylaw infraction or breach is occurring? Given the fact that this is the first time you're sitting, we thought it would be prudent to have our legal counsel, Patrick Kramer, attend, so he is virtual. I understand we're still having potentially some technical issues, so Holly might be doing some interim translation between. But Mr. Kramer won't be here all the time. It will likely be just staff, but considering this is your first meeting, if there are any legal questions, we may defer them to Patrick. I'll leave it up to him as you are asking questions. If you do engage and have legal questions, there will be, most can occur in open forum, in open discussion, but there may be situations where you ask a question and it may be more appropriate to go in camera. That is perfectly acceptable because you are getting solicitor advice and there's provisions under the act that allows you to do that. You'd have to pass a motion to do that, and it would be covered under solicitor client privilege. But I'll leave it up to Mr. Kramer, should you ask a question, to identify that it would be appropriate to go in camera or not. And then just after we finish with the matters, I'd like to do just a quick chat with the committee afterwards about sort of next meetings and what we can do to get you prepared for next meetings, if there are any, as we go forward. So with that, that's my speech, Mr. Chair. I'm not sure if Mr. Kramer wants to pipe in through Holly or
Are you able to hear me now?
we can
Yeah,
hear you.
you're good
Yes,
now.
there we
Great.
go.
Well, amazing technology. When all else fails, reboot. So good morning, everyone. My name is Patrick Kramer. I'm a lawyer. I'm sitting right now in my office in Kitchener. Have been up to those township office, and sorry I couldn't be with you in person. I am here to provide you with any advice in terms of the role you need to play today. In addition to what Mr. Melanson said, I would draw your attention to a section of the property standards bylaw, and that is section 66.5. And that section says the Property Standards Appeal Committee shall hear the appeal and shall have all the powers and functions of the property standards officer. And you may confirm, modify, or rescind the order, or extend the time for complying with the order. So if you do any of those things, then it will be enforceable as though the order had been issued by the officer. I'm not sure if the committee has sat in a role like this where you're hearing a type of appeal. Maybe some of you have on other committees like Committee of Adjustment, but I think the process that Mr. Melanson has set out, it sounds appropriate. I mean, one of your main things is to give an opportunity to hear both sides, and to be fair. You can issue oaths if that's appropriate. You're just going to ask, the witness, including the appellant, to either they can swear if they want to on a Bible or other holy book, and or they can just say that they affirm to tell the truth. So I don't know if you need any other instructions, but I'll stay here. I'll mute myself. But if you need some input from me, I'm here to assist.
Well, we'll start with 6.1, Property Standards Order Appeal, 71 Osprey Street, Dundalk, Ontario.
So the order to comply is attached to the agenda that you guys would have been sent. Do you have any questions right now for our bylaw enforcement officer about the order to comply? Or perhaps, yeah, Hannah can maybe give her report now before we get to the notice of appeal.
Okay, thank you very much for that. Can everyone hear me appropriately? Yeah. Okay. So the order to comply, just to confirm, is the one dated August 12th, 2024. That is the order to comply, which is being enforced. So what I'm going to do is a synopsis of the entire file. And then if you have any questions after that, you can ask me. So on the 7th of June, 2024, the initial complaint was received into the township through our cloud permit system, which we have just started using. And the complaint was there were two unplated vehicles sitting in the driveway of the residence at 71 Osprey Street South in Dundalk. On the 10th of June, 2024, I went and did an inspection of the property. I found one vehicle with no plates on it at all, and another vehicle with one rear plate with a 2022 sticker on it for registration. The address and the contact information for the property owner was confirmed through our township records, and that showed up as 1,735,230 Ontario Incorporated as a legal property owner. I then sent a violation notice to that legal property owner, informing them under the property standards bylaw, the two vehicles either had to get plates attached, current and registered to those two vehicles, or they had to be removed. And both of the vehicles were a Toyota make. Then on the 16th of July, 2024, I conduct an inspection for compliance for the violation notice. Again, both vehicles were still exactly where they were previously, no plates attached, they hadn't been moved. I again knocked on the front door of the residence, received no response, and left another business card. On the 18th of July, 2024, I then sent an order to comply, which was mailed, registered post to the legal property owner. A compliance date of 19th of August, 2024 was given. 22nd of July, 2024, both the violation notice and the order to comply came back to the township as undeliverable, incorrect mailing address. I went and confirmed with taxation department that the address we had on file was correct. And they said, as far as they were concerned, the address was correct. And that's the address we had for the legal property owner. I then got the email to the legal property owner through township records and emailed the order to comply to the legal property owner. Then on the 24th of July, 2024, the legal property owner contacted me confirming he had got the order to comply. However, he also stated that it was a rental property and he did not own the vehicles located on the property, and he believed they belonged to the tenant. I explained to him that under the property standards bylaw, anything on the property would fall onto him as a legal property owner, even though it was being rented out to a tenant. He said he understood that and confirmed he understood that, and he would contact the tenant and organize to get the vehicles removed or get the tenant to plate the vehicles appropriately. Then on August 12th, 2024, a new order to comply was issued as the appeal he sent to the township was received past the final date for appeal on the previous order to comply, and it was no longer a valid appeal form. That is why a new order to comply was issued. And I did a new compliance date of 9th of the 2nd, 2024. I have spoken with both the tenant and the legal property owner. The tenant verbally confirmed to me over the phone he does in fact own both vehicles of a Toyota make, and he indicated he would get them registered and plated. But I have not heard anything since then, and the vehicles still are not registered and plated. And that's my synopsis, if you have any questions.
Just to confirm, the owner of the property, the email that was provided, Deepak surname, that's the tenant, not the owner?
That is the legal property owner. That is their email address.
So there was included in the agenda, the appellant statement and the notice of the appeal. The statement has more information than the actual notice, the second file. Everyone's had a chance to review that file. And is there any questions surrounding the appeal?
Property owners.
I don't believe so.
Sorry, I'm confused a bit. So the property or the property owner owns the property, obviously. The tenant's got the vehicles. The township comes in and says, we want you to do this. So what, like, is there fines involved? Is there like what? That's the part I need more information. Just I'm confused.
For sure. So the property standards bylaw is the Ontario Building Code Act, which is the governing authority for it. So in terms of fines, what would happen is it would actually proceed to court if the order is upheld, and then a justice would basically make the decision on fines. So I don't issue fines myself directly to the property owner. It is the courts.
So maybe if I could add, Mr. Chair, through you to the committee. The property standards bylaw sets out general standards that all residents have to observe in maintaining their property. So it deals with things like your grass not getting too high, weeds, general appearance. And part of that, and Hannah can correct me, I don't happen to know the exact wording, but generally speaking, vehicles that are stored on your property need to be in good working order. They need to be legal in the sense that your plates are registered and proper insurance, that sort of thing. In this case, we had a complaint received that was indicating that these vehicles were not properly plated. I'm not sure, and maybe Hannah can comment. There might have been a question of if these vehicles could even operate, but that's the breach of the bylaw that is the subject of the order. So what happens is when a complaint is received, we would investigate the matter first to determine if a breach occurred. So the fact that you're here today, Hannah has given in her synopsis that there was in fact a breach, that she gave them direction to comply and a date. There were some mitigating circumstances because of the address information not being valid. And so she did extra work to try to find a way to contact this property owner and give them an easier opportunity to appeal, given the fact that the notice didn't go to where it should. And now that's why you're here, is that we've reissued that order, but the breach, in our opinion, still remains. So going back to what the preamble I gave you, you have to make a determination based on what you hear today and what you have in your package, and anything that, the property owner has given you a letter. You need to weigh, is the breach still occurring? In which case, if you feel that it is, then the order is valid. There was a valid reason to issue it. So then the next question would be, has the municipality been fair in terms of providing a reasonable amount of time to remedy the situation. And it's, Patrick and I could probably get into a legal debate that would last the morning, but it's not the idea of, is it actually truly fair? It's seen to be fair is the idea. So were we reasonable and procedurally fair? We issued a notice, we give you 24 hours. Is that reasonable? So now you've got the question before you. Is it reasonable to have gone to an order? And is the amount of time that's been provided reasonable? I hope that helps.
I can, oh,
I just have a question just for clarification. The email we were provided is, and the first name starts with Tanella Deepak. That is the current registered owner of the property or the tenant of the property?
that is the current registered owner of the property, and he confirmed to me that he is part of the corporation, if you like, that's registered as the legal property owner, because it is a corporation, not an individual who's listed as the legal owner of the property.
So does the tenant know that this is happening?
Yes, the tenant is aware this is happening. I spoke to him directly over the phone. I made him aware there was an order to comply that the legal property owner had received. I explained it to him and also informed the tenant if he needed more information on the order to comply to reach out to the legal property owner, which is the corporation. And he said he would, and he understood what was required, that the vehicles both needed license plates and the license plate, had to be current and registered to both of the vehicles.
Thank you.
So I would just extend on what Ken was saying before. So the actual violation on the order was under section 3, subsection 3.2E. And it says in the property standards that vehicles must be licensed, and these two vehicles were unlicensed. One had no plates, the other one just had one plate on the back, but it was from 2022, as confirmed by the tenant who said he owned the vehicles. So that's the violation. And both vehicles did appear, just to look at them, they did appear operable. But again, I have to just look at the vehicles. I'm not a mechanic by any means. So I just have to look at them, and if they have tires that aren't flat, no big pieces missing off them like a door, something like that that's really obvious, then normally, yes, I say they appear operable because I'm not a mechanic.
We don't have any photos of this site?
Yes, we do.
Can we share them?
Photos. Okay, so I do have some photos here. I'll just pull them out of the electronic file and then you can view them.
Just had a question in relation to the first photo. I'm looking at a photo with a red, I believe Toyota vehicle parked, disappears on the front lawn of a residence. The residence directly behind is the residence of the matter today.
That is correct, yes. The residence directly behind is part of the same property.
And then a second picture of a blue vehicle, I'll just call it a blue vehicle. And then it looks like an alleyway. That is confirmed on their property, the same property by property.
That
line.
is correct, yes. That is confirmed to be on their property.
Thank you.
So, Mr. Chair, the photos that are coming around are the same photos that you're seeing on the screen. So you can either look on the screen or they're circulating around to the committee.
License plate registrations are free now, right? All he has to do is get that plate registered and that car will be legal. Is that not correct?
Correct, so he just has to get the plate registered and then it would be legal according to the rules since they've been changed.
I have a question. Does the vehicle get plates on it, the vehicle that's unplated, do they have to be certified by a mechanic before they can put a plate on it? Would that cost be involved?
So we don't have anything in the bylaw that dictates it has to be inspected by a mechanic. All our bylaw says, is that they have to be licensed. So as long as they have a plate on them that matches that vehicle, then, and it's valid, it's a valid plate, then they would be fulfilling the requirements of the bylaw. We don't require a mechanic report or anything like that.
So in that case, there's not really going to be any financial problem with getting this done if the plating is now free. We're not talking a lot of money or anything.
Yeah, that is correct.
Okay.
I don't look into whether they've had, like I said, an inspection by a mechanic.
Mhm.
I'm just looking for plates that match that vehicle that are valid on the vehicle front and back. Unless it's a vehicle that doesn't normally have front plates. I know some cases they don't have a front plate.
Thank you.
I don't believe the property owners in you're the next file, right? Okay. So the property owner is not present. So all we have is the included letter that's on the agenda from the owner.
So, Mr. Chair, Holly has placed that letter on screen, which is included in your package.
So that letter, that's from the property owner or the tenant? The property owner wrote that letter. Okay.
And I notice on the letter, due to various financial obligations, I'm struggling to allocate funds to these expenses. But apparently there's no expenses involved if it's just a question of paperwork with the Department of Transport or whatever it's called now.
Correct, yes. So again, I don't look into paperwork, what they have and haven't paid for.
Yeah.
All I'm looking for is license plates on the vehicles that are valid and match that vehicle. So if he puts a license plate on, or anyone puts a license plate on for, say, a truck, but they put it onto a car and it's a completely wrong vehicle, that is not good enough either. It has to be matching that vehicle and a valid plate.
Mr. Chair, if I could just add the plate itself no longer has a cost, but under the new provincial regulations, it doesn't automatically renew if you have any outstanding parking fees or fines or anything like that. So we don't know whether that would be the case. That is all maintained by the province. But really, financial matters are not a major consideration for you. The issue becomes, is the breach still active? And if so, have they been given a reasonable period of time to deal with the matter? And there's no way for us to know whether a plate would have fines or not.
I just have one question in relation to the email received September 18th, 2024. And in the body of the email, it said, I would appreciate, and the person was here, I'd ask them this, but they're not, so I'll ask the bylaw officer. I'd appreciate any guidance on potential alternatives to resolve this matter. And I believe on the 24th of July, 2024, you did directly speak with this person. Did they ask for any assistance in relation to this matter?
That is correct, yes. I basically told them that there was two options really they had with the order, was either tell the tenant, because the tenant informed me that they legally own the vehicles, inform the tenant that they had to be removed, or get plates on the vehicles that match those vehicles and were valid. There really is no other way to do this. The way the property standards bylaw is written with that particular section. So that's what I told him, and he agreed and said, okay, I will look after it, let the tenant know. And that was as much information as I could give him in terms of an alternative.
Thank you.
How much exactly time did you give them? Like,
Total time?
from the second order. When. Now, I guess, so, yes, thank you.
Okay. So the new order to comply, which is the one we're looking at today, it was issued on August 12th, 2024, and it was emailed to the individual. And then I provided a compliance date of 9th of the 2nd, 2024, to have the vehicles and therefore the property in compliance with the order. And then the property owner also indicated that he wanted to appeal it. So he's also had more time, including the appeal, to have the vehicles plated or remove them.
It would be cumulatively, just with the date of the appeal, just to give a number. From the date of issuance of Hannah's order to when the date of compliance would be just under 1 month. We're now approaching 3 months from the date in which the order was given. And also keep in mind, this is the second order. So there was also time before that to comply as well.
Yep, this thing. So with the first order, we're into how many months? 4 or 5 months roughly? Since the beginning to now?
3.
Yeah, approximately 3, because the first order to comply was mailed back on July 18th, but then it ended up coming back, and then he got the order emailed to him, and that was shortly after July 24th. He actually got the order via email and confirmed he had received the order and understood what entailed the order to comply when I spoke with him on the phone.
So I'll just confirm that this basically began in June 7th. The first time you actually, because some things were returned, service was returned, unclear whether it got to the owner of the property or not, but on July 24th, you can say that was the person knew the order was in place.
That is correct, yes. So from July 24th, the legal property owner was aware the order was in place. He confirmed he was aware what he had to do to come into compliance with the order. And he also confirmed that the tenant would be advised of the order and that the tenant would also be told exactly what he had to do because he was the one that owned the vehicles, not the legal property owner.
Thank you.
Yeah, so at this point, I think we've went over most sections of the agenda. So I'd say we're at 6.15 committee discussion, which can lead into a committee decision. So whether the committee wants to deliberate amongst themselves, and I can help with wording of a decision once we come to that.
Anyone have any questions? Any more discussion? I think we should render a decision.
So depending what the committee wants to do, I have wording that would uphold the order issued. But it depends what the committee wants to do.
Mr. Chair, I look at it in 4 different areas. One would be, is it within the legislation for this matter to go forward, which I believe it is? Proof of service, which I believe on the evidence today is there. Do we have the correct property and property lines, which I believe we confirmed? And was a reasonable notice to the person and the tenant? And I believe we hit the 3 that I should be talking to my committee. I believe that we've satisfied those 4 things.
I would have to agree with what you just said.
Yeah. Agreement.
So it sounds like the committee would like to uphold the order. So I have be it resolved that the committee uphold
Yes.
the order. Uphold the order issued by Law Enforcement Officer Hannah Combs on owner Deepak Tanej of 71 Osprey Street, Dundalk, for violation of section 3.3.2E of the Township of Southgate Property Standards Bylaw number 2019-111, issued on August 12th, 2024, with a compliance date of September 2nd, 2024. So that would be the motion to uphold the order. So we would just need a mover, a seconder, and a vote on that motion.
I'm sorry, I'm just going to interrupt you. I think the better language on your motion instead of uphold is to use the term confirm.
Confirm? Okay, I will switch that. Thanks, Patrick. So we have mover and seconder, Doug and Robert. So just the vote.
Vote. Upheld.
Upheld.
Carried.
Okay. So we can move on then, Mr. Chair, to
We're on to the next one, which
Second
is 6.2 Property Standards Order Appeal. 146-345 Southgate Road 14, Dundalk, Ontario. There's an order to comply. Notice of appeal and statement. Notice of hearing of appeal. And bylaw enforcement officer's report. You have the floor.
Okay, so this file, I will advise the committee, has been ongoing since 2023 with the initial complaint laid to the township back in 2022. So based on legal advice, I have reinvestigated the file. So on May 10th, 2023, there is an order to comply in this file that was sent to the registered property owner, Shane Remtula, and also Sean William Wright at that time. They were both listed as registered owners with the Township of Southgate for this property. The mail came back as moved unknown. So the order to comply was never received. The address at that time was 90 Hinchley Wood Grove, Brampton, Ontario, L6V3M3. On February 26, 2024, I completed a request through the Ministry of the Attorney General to attempt to locate the current address and mailing address of the legal property owners, who still showed as Shane Remtula and Sean William Wright. This was unsuccessful through the ministry. On August 1st, 2024, I attended the property and conducted an inspection for both property standards and zoning violations. Multiple items and concerns were observed, including but not limited to garbage, rubbish, waste, litter, and inoperable vehicles. A search of the township records again found that the legal registered owners still had a current mailing address of 90 Hinchley Wood Grove, Brampton, Ontario. There was no phone number or email address associated with this property or the registered owners. On August 8th, 2024, a land title search conducted by the legal firm assisting the township confirmed for this particular property, the current residential address for Shane Remtula was 21 Robinson Road, Mono, Ontario. These records were emailed to myself by the legal firm. August 14th, 2024, again, based on legal advice, the order to comply was still sent registered post to the mailing address held on file by the Township of Southgate of 90 Hinchley Wood Grove, Brampton, Ontario, L6V3M3, with a compliance date of 31st of August, 2024. Then on August 15th, 2024, I attended the property in person. Now, this property was 21 Robinson Road, Mono, Ontario, to deliver the property standards order in person to Shane Remtula. When I attended, she was not at the residence. I spoke with Naslin Remtula, who confirmed that she did reside at that address, and she would provide the property standards order to Shane Remtula. I left my business card and instructions for Shane Remtula to contact me with regards to the order to comply for property standards at the property in Southgate.
Sorry, what was that date again?
August 15th, 2024.
Thank you.
Just a couple matters of clarification. One in relation to the address, the 146345. Who is on title at that property? Both, or Shane and Naslin, or one? Or
So the current records for the title for that property show that Shane Remtula is now the sole owner of the property, and Sean William Wright is no longer an owner of the property.
Thank you. And second of all, just in the email provided to there's no date on it. It's blacked out, but the person that wrote it, I believe Shane, referred to the bylaw and police asked squatters to leave the property. I just wanted confirmation if that actually happened.
So when I attended on the 18th of October, I did find squatters were still on the property, and I attended for another matter, not related to property standards that particular day, but I can confirm, yes, there were still squatters living on the property.
I may defer to Patrick on this matter, but in relation to squatters versus tenants versus owners, the language of squatter to me means something different legally.
So Patrick can confirm with me after I say this, but my understanding squatters is they don't have the permission of the legal property owner to actually be there. They essentially have moved onto the property without the property owner's permission.
Hey, Patrick, it's 10 years, isn't it, of squatting that before someone has, and I'll that's all I'll say. I'll leave it to you.
Well, I think Ms. Combs gave a you know, a good response there. I mean, essentially they are they're trespassing, so they're trespassers. There is such a thing as you know, squatters' rights, I guess, is sort of a common term, or, you know, possession by being on the property for a certain number of years. That is quite a difficult legal hurdle to cross. I'm not sure that you need to deal with that matter. Ultimately, the owner is responsible for what's happening on that property, whether it's trespassers, tenants, or anyone else, and they can be held responsible for causing or permitting, you know, essentially not taking positive steps to address, you know, the violation that's been brought to their attention.
Thank you.
Hannah, if I might ask you one more question. When you attended the property and you said there were squatters there, did you have any interaction with them?
I've interacted with them for other reasons. And they informed me, basically that they had been given permission by one of the legal property owners to be there at the time. Now, bear in mind this, like I said, this file has been going since 2023, 2022. And I was informed by the two people at the time who were there when I attended that they had been given permission by Sean William Wright to be on the property. I can't confirm or deny that. That's just what I was told.
Thank you.
Sorry, you said another name there. Who was allowed them to stay at the property?
Sean William Wright, who was another legal property owner, but he has since been taken off title.
Are you aware of any tenant agreement between Sean, any of the parties with the people that are, I'll call them trespassers, that are in this residence now?
I am not aware of any agreements. No one's ever produced any signed agreement to that effect. I haven't seen one.
Thank you.
Mr. Chair, just wanted to also make sure the committee is aware that in providing the order, the now sole property owner is advised once the appeal is deemed to be valid and the committee is brought together for a hearing, that they can be in attendance virtually or in person to speak to the committee related to the order. And I think we do have some folks here to speak to this matter. So just wanted to bring that to your attention when the time is appropriate. They may wish to speak to the matter as well.
Are either one of you involved in this? Yes? Yeah.
Yes, my name's Shane Ramtula.
Okay.
Sorry. So, I just wanted to bring this appeal to the committee and Mr. Chair. My ask for the appeal is that the date get extended. I did contact the Gray Police and I do have an incident number that they did provide me with. I have contacted them afterwards, and the next steps for me are they will escort me to the property to provide them with paperwork. I have gone to the landlord tenant board. The approximate timeline from them is about 5 to 6 months, at which time then they could issue them an order to leave the property. But my first steps that they told me are to go with the police department if I feel comfortable, which is the only way I would go there, and to get that paperwork done. So I'm here today to ask for an extension to July 31st to allow 5 to 6 months to go through the Landlord Tenant Act. Once the squatters are evicted, I can then do the property cleanup. But I am not comfortable doing the property cleanup due to safety while there's still squatters on the property.
Thank you.
I have a couple
And-
questions.
Sorry, yeah.
One, referring again, the squatter, are they people that are trespassing or there's a tenant agreement that would take into the Landlord Tenant Act?
They have no agreement to be on the property. They're trespassers. I was made aware of this once I received the compliance forms, and I have gone to the property to try to talk to them as well to ask them to leave. I was able to contact one person, but there are other people. The person on the property indicated it was very unsafe for me to be there and to come back with police. So that's the next step where I printed out eviction forms to the best of my ability, and then to take the next step to provide it to them.
So what happened when the police attended with you?
The police said they couldn't do anything. I had to basically come back, issue them a form, and they said it's a civil matter. I have to go through the correct process of the landlord tenant board and then go through the legal proceedings because they wouldn't leave on their own.
Are they tenants or not?
No,
So they're trespassing.
they're trespassers.
So, okay.
Any other questions?
Yes, where are they staying?
Currently, they have put trailer on the property and they're staying inside of a trailer.
That's not your trailer.
Nope. Nothing on that property. That property was vacant. During the court proceedings at the time I was going for sole title, the squatters had moved in. The court proceedings did last at least 1 to 2 years. The squatters moved in during that time. So now I'm going through the process now that I've full ownership and title to be able to remove them. They have no agreement to be on there. And there should be nothing there.
And you're sure there's no agreement with the previous person? Sorry, Wright was the person's surname?
That's correct. I did go through the court to make sure that everything came out and to make sure that there was no issues with me having the sole title.
And they have no agreement from him previously to stay at that residence?
No.
Thank you.
So, Mr. Chair, just as you continue to deliberate, I don't mean to interrupt, keep asking questions to the property owner representative. I'm just going to hand around the photos that we have for the file. Unfortunately, we don't have them to be able to put on the screen, but we do have them here physically. Thank you.
And at some time later, may I get a copy of those photos as well? Okay.
I guess I have a question for you. Have you, is the whole process through the Landlord and Tenant Act of evicting these people, is it in motion?
Yeah, the first step they said before I can file the motion is that I have to serve them with paperwork and make sure I ask them to leave, not verbally, which I've done, but do it through paperwork, which is where I've made an appointment with the sheriff for them to be able to go with me to serve it. The issue too, as well as I do not know their full names. So I have to go with the sheriff to be able to do that. Otherwise I can't file as well.
And that's in process now?
Yes.
Thank you.
How did these people arrive at the property and pick your property, unfortunately, I guess?
I think it's a good piece of vacant land that has access to the street. And it was a good location to do it. And it just happens sometimes. It doesn't even have to be the vacant land. It could be anywhere where the squatters just pick a place and go.
And just some clarification, if they're not tenants, why are you going to the Landlord Tenant Act? I would assume they're trespassing then.
Yes, but the best way I could find online through any advice is to go through this process. Otherwise, I don't know how else to approach it.
Thank you.
Any other questions?
Again, what did the police say to you when you told them these people were on your property?
The police said I had to go through some other legal proceedings because the trespassers refused to leave.
And they threatened you with danger?
So they just refused to leave. I have talked to one of the people on the property who indicated to me, and they said they'd be willing to put that in writing if they had to, that there may be other people on the property as well, and it wouldn't be safe to go alone. The police have also been to the property several times, so I want to make sure I have a escort or somebody with me as I walk. It is a large piece of land.
Basically, all the stuff we see in basically all the stuff we see in these photographs, and that's all stuff that the squatters or the trespassers have moved in onto your property.
That's correct.
Thank you.
Any discussion? Any comments?
Problem.
So, Mr. Chair, if I might make a suggestion, and I hate to put Mr. Kramer on the spot, but we may want to perhaps have him chime in on some advice, because this file is a lot different than the first one that you dealt with. There's some mitigating circumstances, and so he may have some commentary for your consideration that might be helpful. I'm sorry, Patrick, that I'm putting you on the spot here.
No, no problem. I mean, do you have a specific question you want me to address or?
I think what and forgive me, committee, I'm reading the room a bit here. But I think that the concern is sort of what direction or what options they could take in this matter in terms of the consideration of what the property owner has advised in terms of the Tenancy Act and things like that, and what advice you might provide for consideration.
Well, first of all, I'm just going to apologize if I start coughing. I've got a bit of a cold. Well, the appellant is looking for an extension of time to comply. She's given a good reason for why she needs extra time. So I think part of it is to determine whether or not, that's a reasonable request and a reasonable amount of time. Now, I'm not here to give the appellant legal advice, but if the appellant says her best legal advice is what she found online, I would suggest that's not good legal advice. She should get legal advice about how to deal with these tenants. I guess I'm not surprised, but I'm disappointed that police force in Ontario will not take action against trespassers when the legal owner, establishes that people are trespassing on their property. But I do understand that that is the state of affairs in our province these days, not just on this property, but on numerous properties. I might suggest a couple of options to you. You might give her the extension of time for her to go through the landlord tenant board, but it's quite a long period of time and that may be fruitless. And she may be back here in, another 8 months or whatever it is and have made no progress. The other thing, you may give her a period of time to go get some legal advice and come up with a plan that's based on good legal advice, and maybe come back to the committee to advise how much time she thinks, based on that legal advice, she's going to need to get rid of those trespassers.
Thank you.
If I could ask you a question, you've indicated you'd like an extension to July 31st, you said?
Yes, that's
So
correct.
that's basically 9 months. What do you base that time period on? Like meeting that?
That's based on 5 to 6 months through the landlord tenant board, where I was hoping the result of that would be that they would issue an order for a sheriff to have the people removed. And then that would then be the next way where the people would have to leave. And then that would give me 2 months to be able to get a company in with dump trucks or whatever is necessary to remove all the debris or garbage from the area.
Thank you.
Any other questions? Any discussion?
discussion to the chair or through the committee. This is obviously a very complex matter in relation to squatter tenant trespass and landlord tenant act. And I'm not, as Patrick, to give any advice. So I just believe that kind of put forth a suggested conclusion. I would support an extension for some further advice, but not for a long period of time because it already has been a year. So whether the committee has to reconvene and I don't know what an appropriate period of time is, but I don't think 10 months, like it should be within the next few months that you could perhaps come back to the committee and tell us what the plan is moving ahead.
I would suggest 30 days should be plenty of time for that.
So if I could suggest, Mr. Chair, and Lindsay can correct me if I'm wrong. This committee only constitutes itself and has meetings when appeals occur. So you don't have a set meeting schedule. So if 30 days is where the committee lands for the property owner to seek legal advice, then your motion would need to clarify that you're providing the property owner 30 days to seek legal advice and to return to the committee at the next available meeting date with a plan for how the property will be brought back into compliance with, is it the property standards bylaw? Yeah, how it will be brought into compliance with the property standards bylaw. Since you don't have a set schedule, what would happen is the property owner would go get that advice and get a plan put together, would contact us. We would then contact the committee to arrange a meeting date and then bring you together. Because we don't have a specific date that we can point to that, bring the plan back to this meeting date, since you actually don't have you're not a scheduled committee, you're a as needed committee, if you will.
Just a process in relation to that, if they decide to get legal advice, and could they somehow send us some documentation in relation to that and then not convene a meeting? But I don't know how that would work procedurally. Sorry.
So through you, Mr. Chair, I might need Patrick to weigh in, because one of the challenges when you seek legal advice is that the deliberations and discussion are subject to attorney-client privilege, right? So this is, if you recall in my sort of preamble discussion, I mentioned that, Patrick being here, there's certain advice or suggestions that he can give it in an open session, but there may come a point where you're seeking a more legal interpretation, and that may need to occur in camera purely because you are getting solicitor advice. So I'm not sure what they could provide. I would really appreciate your assistance here, Patrick. Perhaps maybe just a letter confirming from whomever it is that they meet with that I did meet with the property owner on this date, and we did discuss options for compliance for said property. That way they're not running afoul of attorney-client privilege. Your thoughts, Patrick? I'll turn it over to you.
I think the committee member just asked about, if they give time for the appellant to get legal advice, could something be sent in and may not need a meeting? I wouldn't advise avoiding a further meeting. I mean, if you're going to give them some period of time, say you need to respond within a certain, if it's 30 days, and maybe you can put in your decision today and a, hearing to be set on, notice, like give 10 days notice of when the next hearing is going to be, and the appellant can come and, lay out her plan, and she can give stuff to you in advance. Maybe if she's got legal advice, maybe her lawyer's even going to show up with her. But I think you should reconvene so the appellant can, lay out for you the plan you're asking for.
Thank you. That answers my question. And just about how long do you think you require to get that information, time-wise?
Ideally, I'd be asking for maybe 60 days.
Thank you.
Any other discussion? I think the 60 days is quite reasonable myself.
So, Mr. Chair, if I may, Lindsay is currently frantically typing to try to piece together a motion for you on the basis of what we're hearing.
Just so I maybe, Patrick, the date is already, correct me if I'm wrong, Hannah, the date has already passed though for the compliance order, right?
That is correct.
So we still have to technically extend it to allow for this. So I'm thinking this wording, Patrick, correct me if I'm wrong. Be it resolved that the committee extend the order issued by bylaw enforcement officer Hannah Combs to owner Shane Ramtula of 146345 Southgate Road 14 Dundalk for violation of section 3.32A of the property standards bylaw issued on August 14th for 60.
I'm going to just jump in.
Yeah, go ahead, because I don't.
That is
I
not
make-
what I would suggest,
Okay,
what I've heard from the committee. You are in an appeal hearing. This is the appeal hearing. The committee can just adjourn the hearing to continue on a further day, and at that time, the committee will make a decision as to whether or not they are going to confirm, rescind, or change the order or extend time. If the appellant, does, and it's possible, I can see that the appellant's here with good intention, but it is possible that an appellant could appear today and then fail to appear later, fail to take any steps and so forth. So I actually think you shouldn't make a decision today because you're still in the appeal. You're just going to adjourn it to, set a date that's about 60 days from now. Or a date to be set. So maybe the wording should be move to adjourn the hearing to a date to be set on 10 days notice, such date greater than 60 days from today. And then you could put, and further, the appellant is advised to provide a plan based on legal advice of how they intend to come into compliance with the property standards bylaw.
Mr. Chair, if that's the desire of the committee, then you will need someone to make a motion for,
Mover,
you'll need a mover and a seconder,
And a
and then you'll
seconder.
need to make a vote. And I'll just make it simple that what Patrick said.
yes.
I'll move that motion.
Seconded.
All in favor? Carried.
I just want to confirm you understand what happened
Yes.
and what the requirement would be next time that you appear.
Yes, I
You
do.
understand? Okay, thank you.
So Mr. Chair, if, just before we go, I do want to say to the committee, congratulations on your first meeting. And just as we've gone through the meeting, I can see that it's getting easier for you. Of course, there's the nerves of your first meeting and what to do and part of what we as staff will do is take some learning from this first meeting too, back with us in terms of how we prep the agendas for you, but also I think we may come to the next meeting with you to have a conversation on the agenda about some training and about, the procedures of the committee, things to consider, jurisdiction, that sort of thing. So just thought I would add that before you make the best motion of any meeting, which is a motion to adjourn.
so just the final motion to adjourn the full meeting.
I'll move.
To adjourn? Carried. We're done.